Welcome to this episode of Divorce, Parenting and Property Matters, Legal Insights by Village Family Lawyers, where we share practical family law insights for people navigating separation, parenting and property matters. Today, we're talking about separation under one roof and what the law actually requires when you and your former partner are still sharing a home, and how to document your position correctly from the start. When a relationship ends, moving out isn't always possible. The financial reality of maintaining two separate households, children who need stability, a property market that makes a second home genuinely unaffordable. These are real constraints that mean many people find themselves still sharing a home after they've separated. What I want to address today is something that surprises a lot of people. You can be legally separated while still living under the same roof. Australian family law recognises this, and understanding what it means and what you need to do matters more than most people realise when they first find themselves in that situation. Let's start with the definition. In Australian family law, separation is not about where you live. It's about intention and conduct. The law recognises that a relationship has ended when at least one party has genuinely decided the relationship is over and has communicated that, whether directly, in writing, or through a clear and sustained change in behaviour. The physical living arrangement doesn't determine the legal status of the relationship. Courts have long recognised the practical reality that separating couples often can't or don't immediately establish separate residences. The concept of separation under one roof is well established. The date of separation carries specific legal weight. For de facto couples, it starts a 2-year window in which property applications generally must be made. For married couples, it starts the 12-month period required before a divorce application can be made. And when the divorce is finalised, a further 12-month window opens for property applications. If the date of separation is disputed later, and it can be, this becomes a significant issue, especially for de facto couples, where the date determines whether an application falls within that 2-year window. Documenting the date clearly and as early as possible is one of the most practical protective steps you can take. A message, an email, a letter, something that can be evidenced if the question arises later. If you're separated under one roof and later need to apply for divorce, the court won't simply accept the claim without supporting evidence. Affidavit evidence is required. That means an affidavit from at least one person outside the relationship, a family member, a friend, a treating professional, who is aware of the separation and can describe what they observed change in the nature of the relationship. Both parties also provide their own affidavit evidence addressing the factors the court considers: whether the parties shared a bedroom, whether meals were shared, how finances were managed, whether they socialised together as a couple, and the nature of interactions with any shared children. None of this is as daunting as it sounds when you understand what's involved, but it does mean that setting up the documentation from the beginning is genuinely important. What changes practically when you separate under one roof? Financial separation is an important early consideration. Continuing to pool finances entirely without any record of separation can complicate later property proceedings. At the same time, taking unilateral action on joint finances without advice can be viewed unfavourably. The right approach is to take considered steps with legal guidance. Communication about shared children and household practicalities continues, of course. Keeping that communication focused on practical matters helps reduce conflict and creates a clearer record of what the relationship actually looked like during that period. I want to briefly address something important. For some clients, the situation at home during a separation under one roof involves genuine safety concerns, coercive control, financial abuse, or family violence of another kind. If that describes your situation, please seek legal advice promptly. There are mechanisms available that go beyond the standard separation pathway, and Village family lawyers can advise on what applies. Separation under one roof is a period of real legal and practical complexity. The good news is that understanding what the law requires and setting up your documentation correctly from the start makes a significant difference. Village Family Lawyers offers a free 15-minute discovery call as a starting point. From there, a 90-minute initial consultation gives you clarity on what applies to your specific situation and a practical action plan. Book at villagefamilylawyers.com.au or call 1300 413 997. The full article is in the episode notes. This has been Divorce, Parenting and Property Matters, Legal Insights by Village Family Lawyers. Thank you for listening.